Good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna, PC. This is our bi-weekly, every 2-week community conference call every other Thursday. We do our best to answer the questions as have been posted, but do remember you are subject to the disclaimers you heard. This is not an attorney-client relation creating phone call, and we can't guarantee the information. We do the best with what we've got. So do not consider this to be a substitute or equal to a one-on-one consultation. I have a couple of questions today that I think are quite long, and I'm not sure how to deal with something like that because it requires so much information and discussion. But I'll do my best in the time that we have. The questions that have been posted, I could only spot one question that I think is a frequently asked question. I don't know if I mentioned this. Today is April 14th, 2022. The way we work this is I will read the question, answer it, and then invite any follow-up questions. No new questions at that point. Follow-up questions only, follow-up to the topic being discussed. Let me just make sure before we go forward that you guys can hear me okay. Just a moment.
The conference is now in conversation mode.
Can you all hear me okay, guys? Can you hear me?
Yes.
Okay. Yes. Thank you. All right.
The conference is now in presentation mode.
So let's begin with the first frequently asked question, the only one that I could see. Somebody has a green card EAD, that means their 485 is pending. They want to hold multiple jobs and or start their own business. So Sanjot says, I'm an IT professional, primary applicant on a 485, which is based upon employment. I haven't started using the EADs, though I'm still on H-1B. So if I decide to switch to green card EAD, question number one, can I work for multiple employers while on green card EAD? Let's say 40 hours per week for employer A and 20 hours for B, or maybe even more than 80 hours total. Is it legal? Yes, sir, it is legal. The only cautionary point here is to remember this. Green card processing has become unnecessarily complicated, but some of the simpler rules to remember are these. One, when you have a green card pending, you have exhibited an intent to take on a job on a permanent basis. Now, sometimes it's a job that you're currently doing. Sometimes it is a job that is in a future job. So it all depends on your particular situation. That's why I said the rules have become unnecessarily complicated. Okay. So as long as you're working for the petitioning employer, one who did your green card, started your green card, you're already working for them, you should have the intention to stay with them on an indefinite basis. This is a requirement on the date you file the 485 and on the date your 485 is approved. You can change your mind after these events. Once your 485 has been pending 180 days, you can change employers. Once your green card 485 has been filed, you can change your intention after 180 days. Did I mention that already? Once your green card is approved, you can again change your intention based upon the facts presented. So intention is basically concluded from your conduct. So if you, for example, let's say you have a green card through a future employer, right? And the green card is approved in about 6 months. You go join them, but you join them with the intention to leave within just a few weeks. So just to complete the paperwork, how do we conclude that? You did not transfer your driver's license. You did not rent an apartment. You did not buy a home. You did not give up the lease in the place where you are working before you joined this employer. So all this seems to suggest that you are doing it on a temporary basis. You don't really want to hang around. Keep in mind that the intention is important. Now, coming back to the question, can I do multiple jobs on EAD? Sure, as long as you have the intention to continue with the focused job, which is the job that gets you the green card on an indefinite basis. You can do multiple jobs at the same time. Okay? Can I work for multiple employers? Yes. Can I work more than 40 hours? Sure, absolutely. 2, if the above is not possible, so that's out. If the above is possible, do both of the employers need to file I-485J? No. You have to focus on one employer. You can have multiple employers file your supplement J. I am not aware of anything that prevents you from doing it. But the only problem is government will use the most recently filed supplement J as your focus employer. Can I do business on the side? Again, you can do business on the side, do 10 jobs, do 2 jobs, do 3 jobs, as long as it is your intention to remain with the focus job, with the focus employer, indefinitely. I don't say permanently because the word permanent doesn't exist in this world. Everything is temporary. But as long as your intention was to remain and you didn't have a preconceived intention that I'm going to run away as soon as I get my green card, you are very well protected in my opinion. Okay. So, please press *5 on your phone if you have a follow-up question. No new question. Any follow-up question on this? Press *5 on your phone. There being no questions, we'll go back to question number 1 or 2 in this case actually, and get started on answering those. Here is a question from Chinna Babu. It's a little unclear. It says, I'm on H-1B visa. My ex-spouse has framed me for her visa. I don't know what that means. Framed me for her visa. And the court has found me guilty. Does that mean that you have been convicted of immigration fraud? I don't know. Press *5 if you are here. Press *5 because I can't tell what you mean. I am on H-1 visa. My ex-spouse has framed me for her visa and the court has found me guilty. It looks like you are talking about a conviction outside the United States. If that is the case, depends upon the conviction, whether it is for a felony or a misdemeanor, whether it is a crime of moral turpitude. So in the worst case scenario, you would lose your green card. You may even lose your right to enter the United States. You definitely need to contact a lawyer and get a lawyer. Maybe in the state you live, somebody who does deportation cases would be a better bet for you. Okay? *5 if you have a follow-up question on this. *5. Next question is using employment authorization instead of extending H-1B. Normally, I advise people to keep their H-1B active. Don't use EAD if you can avoid it. When you have a 485 pending, you have more protection that way. So here the question is, currently on H-1B, filed for I-485 in November 2020, downgrade from EB2 to EB3, received I-485 EAD and AP, never actually used them. I-140 approved both in EB2 and EB3 category with current employer A. Re-entered USA on H-1B stamp with only few months left on H-1B. Can I choose not to extend or transfer H-1B? You can, but I think it gives you more protection. And how do you use EAD? You use it exactly the way you said it, where you submit an I-9 instead of the H-1B and the employer revokes the H-1B. Also where you in fact start working on more than one job, you would have lost your H-1B. Do I and my family go out of status if I happen to switch to a new employer B? Well, the moment you start using your EAD, you are no longer in status. You are in authorized period of stay, which means you are legal to stay, but you don't have full status. If I happen to switch to using EAD, especially with, I don't know what this is. Do I and my family go out of status if I happen to switch to an employer B after H1B ends using EAD? No. Okay, I think I kind of understand what you're asking me. The sentence is a little difficult to comprehend. But the way it works is, once you have your EAD and you're working on your EAD, you can work, not work, work a totally different job from your main field, work 3 jobs if you want. Like I said, not work if you want. But the smart thing to do, again, listen to the first question I discussed today, the frequently asked question. It's your focus job. You should have the intention to join it on an indefinite basis. So the fact that you are in the meantime not working is not a problem, but you should have the intention to join the permanent job, the focus job, on a permanent/indefinite basis. So the gap in employment does not matter. And there is no 60-day grace period once you are out of the H1B process. Okay? When you're an EAD, there is no limit to how long you can stay unemployed, as long as your focus job is available and you want to take it up. Okay? If I submit for an interfile to change back to EB2, you cannot do that. Government has now said, which I think is kind of crazy, but the government has said that you can only interfile once. So if you wanted to go back to EB2, I think you would have to file another I-485. And that would reset your adjustment of status 180-day pending clock. Yes. For the subsequent usage of EAD AP, no. There's no 180-day clock for using advanced parole. So there's a lot of confusion in these questions. I'm not sure what you're asking me. Rahul, are you on the phone? Press *5. Yeah, I'm not sure what you're asking me here. 1 second. Area code 509. Where are you calling from?
Hi, I actually have a question as well. Whenever you get a chance, can I ask you?
Not right now. You can only ask me new questions when I ask for input on new questions, which will be the end of the conference call. Okay. So.
Okay.
Yeah. So going back to Rahul, I'm not sure what you're asking me. Quite confusing. If I submit to interfile, so I have no idea what you're asking me. If AOS EAD for EB3 is already used, can you still interfile? Yes. Look at my blog entries. I think 3rd or 4th entry talks about this, because this is what the government said in a conversation with the American Immigration Lawyers Association. Yeah, just because you used your employment authorization does not stop you from interfiling. Okay. Any follow-up questions on this? Press *5, please. Any follow-up questions? Press *5. Okay. So traveling outside the US during H4 EAD process. So here, what is going on is, I am on H1B. Tom says I'm on H1B. 6th year of H1B is expiring on September 30th. Less than 6 months left. Green card process is started, but we are not at the stage where we can get an extension based upon the green card. So now the H4 EAD is going on. Okay, H4 change of status, H4 EAD is going on because his spouse is also on H1. If I don't get any approval by September, would it help if I go to India or Canada for H4 stamping? I haven't worked out the details and the logistics, but I understand that it can get faster if you can get H4 visa stamping. I'm not sure the EAD gets faster, but it might. It might. I don't have any personal data on this that I can cite to. If the answer is yes, the answer is maybe, I think so. So it's not yes. I have converted multiple visas after my last entry H4 to F1. Do I need to go to home country? No. You can go to any country that will take your application. Should I just wait for my H4EAD or I-140 and H1B extension to be approved to resume my work? No, I think you should get back on to, first of all, to stay here, you've got to be on H4. So you've got to convert to H4. Then to work, you either have to get the EAD or get back onto H1B. I hope I don't need to leave the country with H4 applied status. No. If you timely filed your H4 change of status, you can continue to stay here while the application is pending. Okay. But if you, for some reason, need to be in a hurry, for example, you got the H1B job offer, it may be worth your while to just go get the H4 visa stamping and then come back and apply for change of status. Why do I say that? Well, you could wait for H1 and then go for H1 visa stamping, but H1 typically has much more uncertainty than H4. So it might be easier to just go get H4 visa stamping, come back and apply for H1 change of status, in case you're in a hurry to convert to H4. Otherwise, you just wait for the change of status to come through. Star 5, if you have a follow-up question on this, press star 5. Okay. We go on to question number, there is a follow-up question. Guys, you got to be a little quick on this. Area code 980. 980, where are you calling from?
Hey Rajiv, I'm from Delaware. Thank you. Thanks for taking my question.
Okay, Delaware, go ahead, please.
Question would be like currently my H1 is approved, right? And it's valid till September 30th. So do you think it still makes sense to go Canada or some other country and get the H4 stamping done and then wait for H4 EAD?
Well, if you go now and come back, you will be on H4, no longer be able to work till September.
Right. Yeah, that's an issue.
Yeah, so you'll have to time it so that you can go right after your H1 is over. Make an appointment as quickly as you can and go for the H4 stamping when the H1 is over. Now remember, once you step outside the country, your H4 application is abandoned. But we don't really care about that. We just want to get the visa stamping and come back. Okay?
Exactly. Yeah, cool.
Good luck.
Yeah, thanks, Rajiv.
You're welcome, sir.
H4 EAD as well.
Sorry, what did you say?
We have filed for H4.
Right.
Will it abandon the H4 EAD application as well?
I think it will.
We have filed for
I think it will. Okay. I know that, but you know what? Hang on one second. USCIS had a frequently asked questions when they first announced the H4 EAD rule, and I believe there were two different situations. I could be wrong about this, but I kind of remember this. When you have an extension pending, you can travel. Okay, but if you have an H4 extension and H4 EAD pending, renewal pending, you can travel. But when you have an H1 to H4, I think you'll have to refile the EAD when you come back, to the best of my knowledge. Okay. All right.
Yeah, because her receipt is also come through, right? So and now it's almost 6 months left. So I'm thinking that it's good to just stay here and wait.
Yeah, I kind of agree with you. I think you're so much time into the process, plus you have another 6 months while you are still on your H1.
Right.
It might be just a good idea to sit back and wait. Okay?
Thank you so much, Rajiv.
You're welcome. You're welcome.
Thank you.
Good luck, guys. Okay. Yeah, that was a good question, actually. Would my EAD also get abandoned? I think it would, because you have a change of status situation. Okay, now, which one were we dealing with? This is the one we just did, right? Yeah. Question number 5. I-485 Supplement J portability to a new employer under AC-21. Employer A, I-140 approved. 485 pending for more than 180 days. Planning to use AC-21, filing 485J with employer B, whom I plan to join when the 485 is approved. In the meantime, can I work for employer C who's paying much more? I think you can, because you have a good reason not to join the employer B for the time being, because you're getting much more money. So I would discuss it with your lawyers, plan out the details, but in theory, I would accept that scenario as possible. What would I want your lawyers to do? I would want them to review the Supplement J carefully, make sure there's nothing that stops me as having this as a future job while I work for another employer. I think there shouldn't be a problem, but let's have it double checked. I get paid to be paranoid. I can't just say, oh yeah, this is going to be okay. Always better to be careful. Okay. *5. If you have a follow-up question on this, press *5. Okay. Let's go on to the next question. Question number 6. This is a pretty confusing set of questions. I reviewed it briefly. I didn't have the time to go over every question, but I did review it briefly. Quite confusing. So, filing for H1 and L1 at the same time. Options if H1B is approved. So when H1B is filed post-lottery or is under process, can I file L1A application simultaneously? Yes, you can. If H1B is approved, does that mean I'm on H1B? You'll be on H1B on October 1st if you are filing now. Okay. So October 1st, you cannot be on H1B before October 1st. Can I file L1A even if my H1 is approved but I have not done stamping? Yes, you can. If I get H1B approved, but I do not stamp before October and my L1 is approved, can I postpone H1? You can just file your H1B as consular processing. That way, you get your H1B approval, but you postpone the status to the time when you either go get a visa stamping or apply for a change of status again. Yes, you can postpone your actual taking up the H1B process through the consular processing device. You can process. Can you postpone it for a year? Yes, you can. As long as the job exists and you have a good reason. If the government asks for a reason, why did you postpone it 1 year? And if the employer has a job still open for you, you can. Can two companies file H1B at the same time? Or one can file if other does not go through within 90-day window of. Well, your lottery cannot, unless both companies have won the lottery for you and they are completely unrelated, they cannot both file. The company who has your lottery winning is the one that needs to file. Okay. *5 if you have a follow-up question on this. *5. Let's go on to the next question. Okay, this is the question is green card for parents. Parents are with me in Texas during I-130 and 485, but the sponsor is in Massachusetts. Where will USCIS schedule biometric appointment? I think when you file the 485, you should give the Texas address because that's where they are living. They don't have to be living where the sponsor is living. Okay, but the biometric appointment comes with a definite application support center as far as I remember. Now, can you go to another center? I do not know the answer to that question. I would say not without some prior arrangements. So call the USCIS help and see what they suggest, but the 485 should be sent wherever they are living according to the 485 address. So Texas was the current address at the time of filing. If that's the address you give, that's where they should schedule them. Okay. *5 if you have a follow-up question. Press *5. Okay, this is from area code 216. I'm assuming that's Texas. 216, go ahead please.
Hi Rajiv, thank you for taking time to answer these questions.
Of course.
So my follow-up question is, so if it's scheduled in Texas, that's fine, no worries. And my parents, and if at that time they are in Massachusetts, they can of course fly to Texas again and do this.
Well, I wouldn't go that far just for the biometrics. what I would do is, as soon as I get notified of the appointment, I would call the USCIS and say, we are now visiting Massachusetts. Could you please schedule us in Massachusetts?
Okay. Okay. Okay.
That's
Yeah,
what
we
I
can
would
always,
try.
yeah.
Yeah.
That's a good suggestion. Yeah, we can. Yeah.
Okay.
And do you know if we can request USCIS to accompany with the parents as a translator during the biometrics appointment?
There has to be a provision for it. I know that we do it for 485 interviews, and there is a procedure for it. There should be a procedure for application support centers allowing people to go in as translators. I don't know what the procedure is,
Okay.
but there should be a procedure.
Okay.
For 485, that's what we have done. Okay.
Okay. Okay. Okay. Great. Thank you so much.
Good luck, sir. Going on to question number 9. So, I got a 221G in the past. Any chance of getting 221G again? See, 221G is a very vague provision of the law. It simply means your paperwork is not complete. It could mean so many different things. You got a traffic ticket in Texas, Class C misdemeanor, which was later dismissed. Okay, this question you should ask of a lawyer who practices deportation law, deportation or removal proceedings or expulsion proceedings in Texas. Why? Because every state has some unique twists to the way they deal with plea bargains. Sometimes you think you are not pleading guilty, but you might be pleading guilty under immigration law. So in that case, the answer would be yes. So I do not know what the answer to this question is, because I do not know which law you were convicted under and what the local law says about that conviction or even dismissal. Okay, so talk with a lawyer who does deportation defense in Texas, if that's where you were convicted. Star 5, if you have a follow-up question, press star 5. Okay, so then you also have another part, question number 3. Can an employer file a transfer while I'm in India? I don't think we call it a transfer, but yeah, it can be done while you're in India. That's not a problem. Can I travel while the transfer petition is pending? You can. I don't have a valid visa. You should wait for the approval from the second employer, then go for a visa stamping. That's the right thing to do. Star 5, if you have a follow-up question, press star 5. Okay. We are zipping through these questions pretty well. So far, so good. So we might have time for new questions. Change of status from L2 to F1. I'm an L2 spouse with EAD working in USA. Spouse has been selected in the recent H1B lottery. Her L1 is about to expire. L1 may not be extended. I've recently secured an admit from an educational institution for master's degree. Can there be a complication if I change from L2 to F1? No, that should not be. It's worth trying. So don't worry about the intention. Don't get bogged down by that. You can certainly try changing from L2 to F1. Star 5, if you have a follow-up question. Star 5. Okay. Let's see. This is question number 11. Case history is employer A filed for my green card in 2020. They filed I-140 concurrently downgrading EB2 to EB3. Okay. I-140 was approved. Advance parole, etc. approved. Joined employer B in March 2022. Employer B also holds my approved EP2 I-140 with the same priority date. Employer B interfiled 485J to change underlying basis from EB3 to EB2. Okay. Now green card is received and approved in EB2 category. Employer A's lawyer received a copy of the 485 approval notice. So it seems USCIS approved green card under employer A. No, you don't really know that. You don't really know that. USCIS screws up sending notices to old lawyers all the time. Other lawyers get our approvals, we get other lawyers' approvals, and all lawyers are uniformly very good about notifying their counterparts. Oh, look, I've got an approval for one of your clients. I'm emailing it to you and FedExing it to you. So we do that all the time. You can't assume that it might be a good idea to double check with the USCIS. Since I-45J is not adjudicated yet, well, you already have your green card, right? You can use your green card. Why not? Nobody can act on any of the pending applications once the green card is approved. So I think what you need to do, make sure that you understand who, why, where, how it has been approved. Also make sure you keep copies of everything with the timing, etc. Make sure your immigration file is complete forever and ever and ever, so that if there is any issue in the future regarding these applications, you are ready with a response. Okay? So what do I suggest? Your lawyers, current lawyers, employer B's lawyers, should get in touch with the USCIS, find out what is going on. Okay? But in the meantime, should you start using your green card? By all means, absolutely. That's the way I would do it. *5. If you have a follow-up question, press *5. Okay, this is from a blocked number, so I don't know who it is. Go ahead, ask your question, please.
Hello, Rajiv. So this is my question, and basically the reason I said about that it may be from employer A because the 485J and the 485 approval happened within a few days. And when I contacted employer B, who I'm working currently with, the lawyer said that the chances are that the 485 was approved based on employer A.
Okay.
So that's where I got a little confused.
Let me just suggest this to you. Step 1, make sure that is indeed the truth. Okay. If it is the truth, discuss with your lawyers what do they suggest you should be doing. Okay. This is one of those areas of the law where there's a lot of confusion because there can be borderline situations. What is your situation? You changed employers, but while the supplement J is pending, they approve your case. With the previous employer, are you safe? I would say you're 100% safe. Why? Because you've obeyed every law. Okay. Can they come after you? I would like to see them try. I don't see any problem. Okay. So in either case, I don't see any problem, but I would like to know. If they have approved for employer B, we have complete repose. But if they have approved for employer A, I think you're still absolutely safe.
Okay, sir. One last follow-up question on this. If I get a better opportunity in next few months, is it safe to switch the employers, or do I need to wait for at least 180 days?
No, I think it's safe to change anytime you get a really good offer, because see, the way I look at it is, like I said earlier, what matters is your intention on the date the 485 or the supplement J was filed and on the date your 485 was approved. If 2 days later Microsoft calls you and says, look, we need a new CEO, can you come take over? Heck yeah, take over by all means. It's a great opportunity.
Great.
Okay.
Thank you so much, sir.
You're welcome, sir. Okay. So the point here is that when you get a great opportunity, which is unexpected, and you were not really looking for it before the green card was approved, I don't see any issue in taking it up. That's a clear-cut case in my opinion. Okay, number 12. Oh, okay, this is the one I think which was too long for me to answer. So I'm going to skip this one. Wow. Yeah, this one is a very long one. I don't know how far I can go with this. I'll see what I can do. But let's skip this one and go on to the How long can I stay? This is number 13. How long can I stay outside the US on green card EAD without risking my green card process? So the question is, I have an advanced parole, I guess that's what you're asking me. Yeah, you can be outside the, ma'am, you've got to stop raising your hand. Put it down, please. Put down your hand. I'll invite for people to raise their hands. Put down your hand. Okay, I'll lower your hand for you. You don't really need to raise it right now. So yeah, you can be outside the United States as long as your advance parole is still valid, and as long as there is no intention not to join the focus employer. Okay, whoever petitioned your green card or supplement J, you have the intention to join them, but because of a moral or a personal obligation, you're outside. I don't see any problem with that. *5 if you have a follow-up question. *5. The only focus here is, do you really have the intention to join the employer on an ongoing basis? The next question, Mira 99, question number 14. Grace period for the job loss, H1B, fresh H1B. Okay, my spouse and I are on separate H1B. I lost my job and my 2-month grace period is almost over. We filed for an H4 within the grace period. Now my H1B grace period is over more than 20 days. H4 is filed more than 25 days. I got a new job offer. Well, you have to go outside USA for H1B visa stamping. And when you travel out, your H4 will be automatically cancelled. Okay? You cannot, it's very unlikely the government is going to give you H1B within the United States. They could, but it's a very, very small chance. Chances are you're going to have to go outside USA for visa stamping to get back onto H1B because your 60-day grace period is over. *5 if you have a follow-up question on this, press *5. Okay. We did this. Now comes the long one. Hey, listen, I'll try the best I can. This is one that you need to do a personal appointment for. Too many issues here. Let me see if I can wrap it up for you. I have an approved I-140 EB3, priority date current. Currently in India, I don't have an H1L1. You should be able to get an H1B. Yeah, you should be cap exempt because of your I-140. I think so. Can one more employer file an H1B for next year through the lottery? Well, why do you need a lottery? You are quota exempt, right? Am I eligible for L1A, L1B? I don't know. Depends upon your classification. Are you coming to work for a related company for whom you're working? Does it make a difference if you're in Canada? Not at all. Not at all. Oh, H1L1 petitions are never denied for immigration intent. They cannot be. These are dual intent visas. H4 also cannot be denied. F1 can be denied if you have an immigrant intent. Well, you can file adjustment of status whenever you come back to the United States and you intend to work for that employer. That's not a problem, but you shouldn't do it if you are on a tourist visa or something like that. If you're on H1L1, you can always file adjustment of status. And the fact that your priority date has been current for 3-4 years is not a bar or an impediment to filing adjustment of status. There's no staleness just because it has gone stale. You can file an adjustment of status as long as your date is current or past current on the date you apply for your 485. Okay. So I've covered all the broad issues that you asked about. *5 if you have a follow-up question, press *5. Okay guys, now is the time. Anybody has any question, press *5 please. Anybody has any question, new, old, anything? Wow, this is not too bad. We only have 3-4 questions. Okay, I'm going to go in the order in which you logged into the okay, 5 questions. I'm going to go in the order that you guys logged into the conference call. The one who has been waiting the longest will get to go first. So let's go to, I think the first one is from Ohio. Okay, Ohio, go ahead please. Ohio.
Hey Raju, can you hear me?
I can hear you. Yes, thank you.
Hello.
Yes,
Yeah.
I.
Hello, sir. I have a question. Yeah. So I filed. I'm on H1B and my wife is on H1B. So we filed. I filed my I-485 a couple of months ago. So my wife is a derivative. So she's planning to change her job. Is it okay while I-485 is pending?
Absolutely. She is the derivative. What she does has no bearing on her green card or your green card. Okay? No problem.
Okay, good. Okay, awesome. And also one more question. So she we also realized her passport is expiring next month. So is it okay to renew?
Absolutely.
The process is pending.
Absolutely.
Okay.
Absolutely okay to renew.
Okay.
And if there is an expedite version possible, get that done. It's better to have the passport in hand. Okay?
Okay.
Good luck. Okay. Let's go on to the next one. This is from New Jersey. One second. I've unmuted you, New Jersey. Go ahead, please. New Jersey.
Yes, sir. Yeah.
Go ahead, sir.
Hello, sir.
Hello, sir.
Thank you for your service as always. I had a quick question. So I'm on H1 and my spouse on H4, and she currently works on H4 EAD. We filed our 485 in September last year, and so far it's still in progress. But so far we have received the EAD/AP combo card.
Okay.
And we have finished our 485 interview a month ago, and we are waiting for the decision.
Okay.
In the interim, my spouse's dad, he's not feeling well. He is sick, and she would want to travel for a couple of weeks to India.
Perfectly safe. Perfectly safe. She has her advance parole. She goes to India. There are 2 possibilities. On the date she returns, her green card is still pending. Cool. She has advance parole. A second possibility, green card is approved in her absence. Still cool. She can get on the flight using the advance parole. When she lands, they will know just looking at her papers that she's got her green card approved. They will let her in anyway. No problem.
Okay. And the third possibility is in case she, would you recommend for going for a stamping in India?
Oh, no. Unnecessary. You are so close to the end. Why take on more pain?
Okay.
All right.
And then if we use the AP, sir, would that impact the 485 process in any way? Like,
no.
Would it cause delays and all that?
No, it does not.
Okay.
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 No worries. Good luck.
All right. Thank you so much.
You're welcome.
I appreciate your help. Thank
You're
you,
welcome.
sir. Yeah.
Okay, let me put your hand down. Let's go on to the next question. This one is also from New Jersey, area code 551. 551, you're unmuted. Go ahead, please. 551.
Yeah, hi. So actually my question is that my employer had filed my firm last year, but I quit the company before the firm was approved because my 6 up reached, and then I got into H4. So a firm got approved after I quit. So now I joined back the same company with H4 EAD. My question is that can I apply for I-140 after I join back on the basis of approved firm with H4 EAD?
The general question is absolutely yes. The technically complicated question is a long one. As far as you are concerned, action item, file I-140. Go for it. Okay?
Okay, so H4 on H4 EAD, I can file I-140.
That is correct. That is correct. Once the I-140 is approved, you can also get back onto H-1B if you want. Okay.
So that perm doesn't get approval, doesn't get wasted, so I can just file the I-140.
I can go into a very long story about how this really works, but your action item is simple. Go with what I'm telling you. If there is a complication, government comes back and asks question, no problem, answer them when the time comes. I think you'll go through. Okay?
Okay, so without any problem, it should go through.
Yes, ma'am.
Okay. Thank you, Rajiv.
Good luck. Let me put your hand down. And now, also, this is from, I guess, Washington State. Washington State, I'm unmuting you. Give me 1 second. Yes, Washington, I can hear you. Go ahead, please.
Yes, hello. Thank you. My question is related to F1 renewal of the visa stamp. So my initial F1 visa stamp expired November of 2019 and my OPT expires May 30th, but I want to go before to India and for that I have to renew my F1. My OPT is approved, I have the EAD card. My OPT is of 1 year. So for the appointment, I've been issued interview waivers, so I have to just do drop off. I want to know what financial documents to carry. I am a resident. I'll start in July. That is what my OPT is for. But I'm still a student right now. I have to finish my graduation May end.
Okay, so let's parse your issues one thing at a time. First of all, when you are an OPT, you should be able to get your F1 visa because you are still a student and you have substantial time left on your F1. That's the way I see it. Can they decline your F1 visa? Yes. Are they likely to? I doubt it very much. Okay. That's one thing. That's one thing. By the way, you said you're a resident. I assume you're a medical resident.
Yes, dental resident.
Dental resident. Dental resident. Are you working for a hospital or a dental institution attached to a university?
Yes, it's Mount Sinai Hospital and their medical school.
Okay. So here is the good news. Here is the good news. If you get stuck with your F1, they can always convert you to H-1B because they are quota exempt. Okay. So I see very little risk for you.
Okay.
Okay.
I do want to add on to that my first F1 stamp was for a university, which I went to for 1 semester and then I transferred.
That shouldn't be a problem. That shouldn't be a problem because did you study at Mount Sinai?
No, I studied somewhere else. And Mount Sinai, I got a job residency there. I matched to their program.
Okay. I don't think transfer of the school reflects negatively on you because you've done it by the book. You've not done anything sneaky. So I'm not that concerned about that part. So now going back to your original question, what kind of financial backing do I need? You need to be able to show that combined with your salary as a resident, you will be able to support yourself. Okay. So have a few $1,000s in the bank. But the fact that you have a job offer should be enough to overcome any financial issues, in my opinion.
Okay, so for the job offer, I have the acceptance letter and one email saying how much my salary would be, an official email. Would that be okay, or do I need anything else?
You should ideally get some kind of an official documentation. You said you have an email. Is that email from the university?
Yes. Because they have not sent me my contract yet, so I just have their acceptance letter that I got into the program, and email saying that I'll earn this much money starting July.
I'm hoping that would be enough, ma'am. It's difficult for me to predict. This is the way I would deal with it. I would go apply for my visa. If they want more documents, at that point I'll approach the university and say, I need these additional documents.
Okay. For my studies that I've done in US, my grandma sponsored me and I showed her financial documents when I first came to US to study. Should I show those documents again?
Why not? If the documents are more recent than the last time you showed them, just get a more recent copy of the same documents. Why not?
Okay, the documents are just her FDs and her property and fixed deposit.
Yeah,
it's not like with any returns.
But these would be very old, right? So you've been here at least a year, right? Maybe 2.
I got my visa in 2015 and then it expired 2019 and now I'm going to renew it again 2022.
Right. So I think you need more recent documents. Okay?
Yes, I will have her make the same documents again.
Yes,
my
ma'am.
RCA.
Yes, ma'am.
So that should work.
I think so.
Okay.
All right. Good luck.
Thank you.
Bye-bye. Okay, so let's skip this one. And now we have the second last question from Arizona. Arizona, I can hear you. Go ahead, please.
Hi, Rajiv sir. Thank you so much for taking these questions. Really appreciate you. I'm asking about a friend. He got selected in H1B this lottery, but he had to travel to India for extreme medical emergency for his mother.
Okay.
And looks like he'll have to stay in India for the next 3-4 months.
Okay.
So me as a friend, we're trying to help him out. Is there a way he can still file for his H1B application while staying
Absolutely.
in India? I mean,
absolutely no problem.
Okay.
Absolutely no problem.
Okay. So he will not.
Oh, absolutely no issue. Have them apply for his H1B. Hang on. Have them apply for his H1B. Okay. He goes for a visa stamping whenever he's ready. And the only thing they will need is a confirmation that the job is still available to him. Otherwise, I have an H1B employee go 1 year after approval for his visa stamping. No problem.
So, let's say if he still stays in India for the next 6 months, he can file
yes, sir.
from there only, get a
yes, sir.
and then after stamping come back.
Yes, sir. But his H1B has to be filed now. And if he's not in a, I have another idea. If he's not in a hurry, let the employer file his H1B non-premium processing. It's gonna take 9 months to get approved anyway. In the meantime, if he gets free of his obligation, they can upgrade his case to premium processing. Okay.
Got it. Okay, I understand.
Good luck.
Thank you so much, sir.
You're welcome. You're welcome. Bye-bye. Okay, the last question is from somebody I guess I've talked with before. Let's see. It's from Missouri. Okay. Last question of the day. Missouri, go ahead, please.
Yeah, good afternoon, sir. Thank you for taking my call. So my question is, we had filed 485 last in 2020 year end sometime. And we've recently completed, not recently, around 2 months back, completed our USCIS interview.
Okay.
So my question is, it's just my doubt that when the firm was filed in 10 years ago, it was senior software developer.
Okay.
And now I'm a project manager.
Okay.
But I'm not managing anybody. I'm not a manager.
Okay.
I do manage projects. So I'm with the same employer.
Okay.
And of course, my location is changed because I'm in consulting. So how does it impact? Is this the reason why USCIS is taking longer to adjudicate my case? Because
okay, let me take a step back. There are some questions I can answer and some I cannot. So let's just begin with your first question. Currently, you're waiting your I-140 approval, or has that been approved?
No. All that has been approved long time back.
Long time back.
My priority date is 2010.
Okay.
I filed 485.
Okay.
and we've even had our 485.
Okay, so here is the good news. First of all, that's not what is causing the delay. Okay, what is important is that your I-140 is approved, your 485 has been filed and pending more than 180 days. You meet all these conditions. Now you could even take the job of a CTO. All you have to do is file a supplement J which says same or similar job. Similar job also means promotions. So if you're getting another promotion or 2 promotions, good for you. You'll still be okay. You'll keep your green card.
Okay. But the 485J that we submitted, even during the interview, so my employer still has being a developer on it.
You can file another supplement J.
So
that's what I would do.
I mean, but I do not want to change my employer.
No. When you change jobs, you should file a supplement J if the job is substantially different. So you said you're not managing anybody, merely managing projects. If I were your lawyer, I would have filed a supplement J at that point of time. And supplement J would have said project manager. Okay?
I see.
Now, that's a decision. That's why I said there are questions I cannot answer. I don't know if the job is same or similar. That's something your lawyers can best tell you. But there is no harm in filing a second supplement J. I don't even know why they are taking so long to adjudicate your case. There could be some other issues, but this is not the problem. Okay?
Okay.
Good luck.
Thank you, sir.
You're welcome. All right, folks. It's always great talking with you. We are done for this call. I'll see you again in 2 weeks. Stay well, everyone. Bye-bye.